Thank you very much, Mr. Speaker. I rise on a matter of breach of privilege, Standing Order 15, and in particular, the question of privilege relates to statements made by the Premier and Minister of Health that were deliberately misleading statements to the Assembly during question period on Thursday, June 3rd, 2021. These statements related to the gathering of members of the Executive Council and the Premier and Minister's statements regarding their compliance with current public health orders during that gathering. Now, Standing Order 15.2 reads, a member wishing to raise a question of privilege shall give written notice containing a brief statement of the question to the Speaker and, if practicable, to any persons whose conduct may be called into question at least 2 hours before the opening of the afternoon sitting and before the orders of the day are called, shall call attention to the alleged breach of privilege and give a brief statement of the nature of the matter addressed in the complaint. Now, I've done so and also, although not required, gave notice to the Premier, the Health Minister, and the House leaders. Now, we must cover at this time what happened for the House to be misled by the remarks of the Premier and Minister. So in this section, we will prove, in fact, the statements were misleading. We'll also prove why this is the first opportunity to review this matter, and also why the ministers knew that their remarks were untrue at the time they were given. We will go over this in great detail and prove that members intended to mislead the House. Now, I'll do my best to be brief, but there's a lot of comments here to cover. So we must discuss what happened for the House to be misled by the remarks of the Premier and the Minister. I will cover this in two parts. First, the remarks that fall into questions, then the direct rules from the Chief Medical Officer's Record of Decision 2021 COVID-19 response regarding Stage 1, Open for Summer Plan, Order 30-2021. The document itself states these rules are effective June 1st, 2021. Now, as far as the House knows, this PATIOGATE event is covered by these health orders. The remarks in question first appear in Hansard on June 3rd on page 5211 to 5215. The remarks in question are from question period on Thursday. Now, in response to the member from Edmonton-Glenora's question, the Premier's response was, quote, Tuesday we moved forward with Stage 1 of Alberta's Open for Summer Plan, which included expanding outdoor gatherings to a maximum of 10 people. We had a business dinner, which we moved outside with 6 people that was fully rule compliant, end quote. Again, in response to the member from Edmonton-Glenora question, the Premier said, quote, followed all of the rules carefully, end quote. And of course, we know that isn't accurate. But also in response to the member from Edmonton City Centre, the Premier said, quote, with respect to the rules, we made every reasonable effort to be physically distanced outdoors rather than doing an indoor meeting, fully compliant with the rules, end quote. And also in response to the member from Calgary-McCall, the Premier said, quote, because they weren't breached, Mr. Speaker, I will refer the honourable member to the Alberta Health Services website with respect to the Open for Summer Plan. It says the following, and I quote, effective June 1st, unless stated otherwise, outdoor social gatherings up to 10 people are permitted. We had 6 people. That's 4 fewer than 10 people. The same rules apply to everyone, and even the members of this legislature, when they are meeting for business, are allowed to follow the rules, end quote. And again, in response to the member from Calgary-McCall, the Premier said, quote, this was an outdoor social gathering, fully compliant with the rules, physically distanced, end quote. Next, I will cover the remarks from the Minister of Health that we believe constitutes a breach. In response to the member from Edmonton South, the Minister of Health claimed, quote, no rules broken, end quote. This is blatantly false, according to the health orders that I will get to shortly. And Mr. Speaker, in response to my own question on Thursday, the Health Minister falsely claimed that, quote, the public health measures were not undermined, and they were in fact in consideration when the event was planned, end quote. And in response to my first supplemental, the Minister of Health said, quote, these are public health measures that were included and considered in the planning of the event. We are now in Stage 1 that allows outdoor social gatherings up to 10 people, end quote. So now we'll go on to the rules. So what I'm about to read are the rules directly taken from the Chief Medical Officer's Record of Decision 2021 COVID-19 response regarding Stage 1 Open for Summer Plan. So Order 30-2021. The document itself states these rules are effective June 1st, 2021. And as far as the House knows, this PATIOGATE event is covered under these health orders. The orders in conflict with the Premier and Health Minister remarks are as follows. In Section 3 pertaining to private social gatherings, it's on page 3, under 3.4, it says, any person who attends a private social gathering at an outdoor public or private place must maintain a minimum physical distance of 2 meters from any other person attending the private social gathering unless the person is a member of their household, end quote. Now, we know that these members were not all from the same household. And we also know that the table would have had to been over 12 feet in diameter, so that's two 6 foot tall people end to end, and that would assume that there would be even spacing by the attendees, which of course there was not, in order to have social distancing around that table. So obviously the table that couldn't have complied with what the attendance that was there. So there was never an opportunity for social distancing, so there was never a plan for social distancing. We will also note for the record, since there were numerous claims online that other rules such as restaurant patio rules and work meeting rules applied. They are still in clear violation of these rules. On the outdoor dining rules, it says under 5.5, quote, an operator of a food serving business or an entity that offers or provides outdoor food and beverage services must A, limit the number of persons seated at the same table to a maximum of 4 persons who are members of the same household, or in accordance with section 2.3 of this order, a maximum of 3 persons for persons who reside on their own. And also require persons to remain seated while consuming food or beverages, and must prohibit persons seated at the table from interacting with persons seated at a different table. So this also means that they violated the patio rules. And for the benefit of the members of the House, I will point out the blatant inconsistency between actions taken on the Premier's patio and the actions that Alberta patio operators are required to follow. Now, under work meetings, it's under section 4.3, it says, an operator of a business or entity listed or described in section 4 of the Appendix A must limit the number of members of the public that may attend the location where the business or entity is operating to the greater of 15% of the total operational occupant load as determined in accordance with the Alberta Fire Code and the fire authority having jurisdiction, or 5 persons. Now, we don't know for sure what the fire code limit would be for that patio, but if it was 15% of that number, that the number would have to be 50 allowed on that patio, and I don't think that's probably the case. And then, of course, if this was a work meeting, of course, we see no papers, but we see lots of wine and scotch. And, of course, by my count, there were 8 people on that patio. Now, the next point was why this is the first opportunity to review this matter. Mr. Speaker, these remarks were made during the last sitting of the House during question period. So this is the first opportunity to give notice of this issue, as today is the first time we're back in the House since then. Pardon me. And finally, the final point, why the ministers knew that their remarks were untrue at the time they were given. Mr. Speaker, this one is very simple. We are talking about the Premier and the Health Minister. They are part of the Special Cabinet Committee that is first briefed and signs off on these matters. They are regularly featured at the Chief Medical Officer of Health's press conferences. And the Minister and Premier spoke at length about the summer reopening plan. So they had to have known the rules. It is their job to know the rules. And this breach of privilege isn't about the actions, it's about what Albertans were told in this House. Now, the Premier and the Health Minister have both now admitted that the rules were broken. So, Mr. Speaker, I believe that this makes this point of privilege valid and proven. Thank you.
Honourable members, the point of privilege is a serious matter to be raised, and typically in situations like this, the Speaker will provide the individuals impacted or a member on behalf of the government, the opposition, other members of the Assembly that would like to provide comments with respect to that. Having just heard the arguments of the Honourable Member for Central Peace Notley, members can choose to respond today, or if they so inclined, can take some time and respond tomorrow at the same time following question period. I will first turn to the government to see if they would like to respond now or wait till tomorrow. The Honourable Deputy Government House Leader.
With your permission, I'll respond now, Mr. Speaker.
Please proceed.
Thank you, Mr. Speaker. It's my privilege to rise on behalf of the government to address the points raised by the independent member from Central Peace Notley. He has alleged that members of the government intentionally broke public health orders and then came into the chamber and intentionally misled members of the Assembly. Mr. Speaker, this is simply not the case. The honourable member's point of privilege is unfounded. To establish that a member has misled the Assembly and it is therefore in contempt, there has been a test that many speakers have referred to in the past, I think you have read these conditions, as every speaker I've ever known has always read these conditions, because it's such a serious matter with a point of privilege. And the test, which I refer to, is found in the 3rd edition of Parliamentary Practice in New Zealand, 2005, at pages 653 and 654, where it states, and I quote, "There are 3 elements to be established when it is alleged that a member is in contempt by reason of a statement that the member has been made. The statement must in fact have been misleading. It must be established that the member making the statement knew at the time the statement was made that it was incorrect, and in making it, the member must have intended to mislead the House." Having reviewed the record of the proceedings in the Assembly last week, we do not believe the statements made by the Premier nor the Minister of Health meet these criteria. And if they don't meet all 3 steps, then of course it doesn't meet the test of a point of privilege. Earlier today, the Premier expressed the following: "I was in the clear view that we were compliant with the open for summer rules." The Premier also expressed regret and apologized, explaining that earnest and honest efforts to comply with the public health measures may have fallen short at points during the event in question. This does not mean the Assembly was misled. It certainly does mean the Assembly, certainly does not mean that the Assembly was intentionally misled. So based on this information and that Beauchesne's 494 states the following: "It has been formally ruled by Speaker that statements by members respecting themselves, and particularly within their own knowledge, must be accepted." The member opposite claims the health measures were intentionally, purposely, and knowingly disregarded, while the government claims that every reasonable effort was made to observe and comply with the public health measures. Mr. Speaker, even in the arguments, the honourable member used phrases like "we don't know for sure" and "it was likely." He's trying to meet something of a high test. With his own remarks has kind of admitted he doesn't know what the circumstances are. Mr. Speaker, I strongly urge you to find that a prima facie breach of privilege has not occurred. I think, frankly, just from the member's own remarks, he's kind of demonstrated that that is the case.
We'll now turn to members of the official opposition. If anyone would like to provide comment, you can provide me notice of comment, or you can provide your remarks now.
Thank you, Mr. Speaker. I can provide my comments. And in so doing, I want to begin by saying that I do believe that there was a prima facie breach of privilege. And I will set out the reasons that why I think that there was a breach of privilege. Chapter 3 of the House of Common Procedures and Practice, 3rd edition, 2017. That will be the most part I will be referring to. Chapter 3 starts at page 88, and it lists at page 89 the list of privileges. And the most relevant one here is freedom of speech and freedom from obstruction, interference, intimidation, and molestation. And with respect to freedom of speech, referring to page 97, that it's one of the most fundamental privileges that is bestowed on this House and courts, and without which the members of this House won't be able to perform their duties. So, as I said, that it's a very sacred privilege, and it comes with a lot of responsibility as well. And on page 97, the House of Common Practice and Procedure, 3rd edition, with respect to this privilege and its abuse, it's stated, and I quote, that there are 2 kinds of institutions in this land to which this awesome and far-reaching privilege of freedom of speech extend: Parliament and the legislature on the one hand, and the courts on the other. Then it goes on to say, that, and I again quote, "The paramount or political and parliamentary system is the principle of freedom of speech, a member right to stand in the House unhindered to speak his or her mind. However, when the debate in the House of Commons is a sensitive issue, it often does. I would expect that the member would always bear in mind the possible effects of their statements and hence be prudent in their tone and choice of words." I do believe that the words Premier used in this House with respect to the Sky Palace party did breach this privilege, and as it's stated in the chapter 46 of parliamentary practices in New Zealand, the test is three-part, which you also have elaborated on July 7, 2020, Hansard page 1763. One, the statement was misleading or not true in fact. And in this case, I think it's very clear that when the Premier was asked about the statements by a member from Edmonton, Glenora, that whether he will admit that he broke the public health orders and apologize, and Premier responded, and I quote, "Well, no, because I did no such thing." That statement was clearly not true. Because, one, I can talk about why it was not true, but earlier today, Premier admitted that he did, in fact, break public health orders, and by his own admissions, it's clear that that statement was misleading, that statement was not true, and the breach of public health order did, in fact, happen, and the response that Premier provided to any question with respect to breach of public health rules on that day was that no, he didn't do anything wrong. And clearly, now we do know from Premier's own admission as well that that statement was clearly misleading. The second part of the test, and I do understand that it's a higher bar, which talks about intention as well, that the member knew that it was a misleading statement. And I think, as I said, that it's a high bar to establish intention, but in this case, it has clearly been established, and I will refer to a few things that why member in question, the Premier, knew that the statement is not correct. And reason for that is that just day before that dinner, Premier and the Health Minister both were at a press conference and elaborating on the stage one open for summer rules. And both the Premier and the Health Minister were part of making those rules as well, because that was clearly within the purview of the Health Minister to come up with these rules on the recommendation of Chief Medical Officer of Health, and Premier is head of the Cabinet and Executive Council, so he was part of that decision making. He exactly knew what the rules were. And while Premier only focused on the 2-meter distancing in his remarks today, there were other health orders that we know and he knew or he ought to knew that were violated. And that 2-meter rule was there throughout this pandemic. And it's a rule that pretty much every Albertan, I can say, is aware of. So the Premier cannot argue that he was unaware of the rule as he sipped his Jameson or sprinkling water. So only instance where a person in Premier possession who was involved in making those decisions can claim that he was not aware of that rule, is that if he was too high on Jameson and other alcohol to the extent that he can be considered as automaton, where he won't be responsible for his actions. But that's not the case. It was, remember, working dinner, and there were important decisions being made there. So the existing public health restrictions clearly state that outdoor gathering must not have an indoor component. This means that attendants are not allowed to go through the Premier's Sky Palace in order to get to the patio. So unless the Minister of Health, the Minister of Environment, Finance Minister, and the Premier Chief of Staff and his Deputy Chief of Staff all scaled the wall and landed a helicopter on the top of Sky Palace or used some drone to deliver all those things, they were knowingly in the violation of this public health order. And the test says that member knew that it was a misleading statement. Since Premier, Health Minister, and all, at least 4 people on that table were the one who came up with this rule, so I would submit that they knew or ought to know that these rules were breached, and the statement they are making in the House are misleading. And third part of that is that member intend to mislead the House. Again, this part also requires that their intention be established there, and that member was misleading the House in making that statement. As I said with respect to the second part of the test, the Premier was in charge throughout this pandemic. Health Minister, we got the same Health Minister, he was in charge throughout this pandemic. These are the people who were making these rules, who are responsible for enforcing these rules. And when they are in a closed space in the sense that the patio is not an unlimited space, it's not a huge space, and they're sitting around a table, you cannot have a table up there big enough that is 2 meters apart and accommodates 8 people. So it was clear to everyone in Alberta that Premier had violated public health orders based on just those pictures. And it's clear that they were way closer than 2 meters. And to claim otherwise is misleading, and to say it in these chambers mean that Premier did in fact mislead this House. And the test here will be simply a reasonable person test, so we can establish on balance of probabilities that intention was there. And I would like to point out to the comments made by the Deputy Speaker of our House and member from Airdrie over the weekend, who said, and I quote, "Looking at these photos, it seems clear to me that several health restrictions were violated," end quote. So it's clear to people, to Albertan, who are just looking at these pictures, that several health restrictions were broken. And any reasonable person in the shoes of Premier and Health Minister would know exactly, or ought to know, what those rules are. And when you're sitting that close to each other, you ought to know that you're breaching those rules. And when you come to this House and say, no, nothing wrong was committed, and in fact, when I asked the question about breaching those rules, Premier even threatened with defamation, that if I say something like that outside this chamber, that will amount to a defamation. So clearly, for the third part of this test, did the member intend to mislead this House? So answer is yes, and we need, intention is a subjective thing. We need to look into whose intention we are talking about. We are talking about intention of a person who was involved in that decision-making all along. He knew exactly, or ought to know exactly what those rules are. He knew exactly what he is saying in this House. And when he apologized today, he admitted that at times he may have been closer than 2 meters. But the picture showed that they were closer to each other than 2 meters at all times. So that statement, I think I would submit that the Premier knew or ought to know that his statement was misleading, that when he said that no public health orders were broken, and he knew it, and everybody else in the province knew it. He just didn't want to face the political fallout from admitting wrongdoing. So he did, in fact, mislead the House in saying that no rules were broken. And second thing I would add with respect to freedom from obstruction and interference, there is no set definition, but in Chapter 46, Contempts Parliamentary Practices in New Zealand, they define the contempt referring to May, that any act or omission which obstructs or impedes the House in the performance of its function. And there was another thing I was looking at. And with respect to privileges, I was reading, I believe, Chapter 3 of the House of Common Practices and Procedure. There are breaches of privilege or contempt of the House, but not all contempts or breach of the privilege. So clearly, a person in authority, a person who is head of the Executive Council of the government of Alberta, when he will make statements which he knew or ought to know that are misleading, that certainly obstructs members of this House' ability to do their job. So, Mr. Speaker, I urge you to take the specific circumstances of this case in account and find that it is a breach of privilege. Thank you.
Honourable members, breach of privilege provides the opportunity for any member of the Assembly to make a submission. Are there others wishing to make a submission? The Honourable Member for Cypress Medicine Hat.
Thank you, Mr. Speaker. And thanks to my honourable colleague from Central Peace Notley for bringing such an important issue forward. I too absolutely feel it's a question of privilege and hope that you will find in that way. Mr. Speaker, it's a question of knowing or not knowing. And the evidence is absolutely overwhelming that the Premier and the Minister of Health would have known. It's been 15 months. It's been 15 months of all Albertans. Social distancing, 2 meters or more apart, wearing our masks, discussing the rules, and doing what we need to do to protect each other and protect ourselves. And Mr. Speaker, let's look at the Premier's role and the Minister of Health's role in this. 15 months of almost daily press conferences with the Chief Medical Officer of Health, going over the rules, going over the case counts, the hospitalizations and the number of people on ICU, Mr. Speaker, also, the Premier and the Minister of Health on the special cabinet committee that so often met to discuss the rules, the regulations, changing the rules and the regulations. I believe they were 2 of 7 people on this special cabinet committee, where for 15 months it's been almost a daily happening. And of course, cabinet, one of the 25 or 30 Albertans that's held responsible for the $61 billion that they're spending annually and getting the rules and the regulations right, working with the Chief Medical Officer of Health and Alberta Health Services. Again, the Premier and the Minister of Health, Cabinet, and the Special Cabinet Committee to oversee these rules. 4 or 5 months ago, the UCP caucus even set up a special caucus working group to bring in more MLAs and more people. And Mr. Speaker, the Premier and the Minister of Health were on that too. Once again, how could they not have known that they were breaking the rules? One of my honourable colleagues mentioned the tweets with the new rules just hours before, and what we've seen for 15 months on Twitter and Facebook, from especially the Premier, but the Minister of Health as well. How could they have not have known that they were breaking the rules? Mr. Speaker, incompetence or disregard or entitlement, absolutely. We've seen both the Minister of Health and the Premier speak at great length about what the rules are, how they apply to people, at times, sharing the compassion for everyone that has to go through this. And when we stop and realize that for 15 months, again, there's been the UCP Cabinet, the Special Cabinet Committee, sometimes called PIC, the Special Caucus Working Group. Every day, the media message with the Chief Medical Officer at Health at 4 or 4:30 or 4:45. Mr. Speaker, the reasonable test is there's no doubt that the Premier and the Minister of Health knew what the rules are. Thank you.
Are there others? Honourable members, as I've mentioned on a number of occasions, a point of privilege of such nature is a significant accusation to make. I think it's best for all members of the Assembly and our House that I take some time to carefully consider the arguments made here this afternoon, and I will report back to the House at my pleasure. Honourable members, we are at orders of the day. Orders du jour.
Motion for